In torts, you cover causation rules in depth, and generally they're the same rules that we discuss, but we're going to discuss them from a criminal law perspective here. Usually, causation is very easy to prove. We're going to see a direct link between D's acts and victim's death. Here's a typical scenario. D shoots V, V dies. Looking at the actus reus of homicide, we can say that V died by the hands of defendant. D committed an affirmative, voluntary act of pointing that loaded gun at the victim and pulling the trigger, and that caused victim's death. I'm not talking about the mens rea, just talking about the actus reus right now. To describe this event using causation principles, we rely on certain legal terminology. Here we would say defendant is the direct cause of victim's death. We say that but for defendant shooting the victim wouldn't have died. Using but for is a nifty tool. It helps identify any force that contributed to victim's death. And it also helps to eliminate any non-essential force. Where defendant is the only actual cause that leads to the victim's death, the only but-for cause, we say D is the direct cause of victim's death. There's nothing between what D did and victim dying. Nothing intervened between his acts and victim's death. Not only is he the direct cause of victim's death, we can say he's the legal or proximate cause of victim's death. But sometimes there are different forces that contribute to victim's death. Sometimes it's not just one person. In other words, sometimes there's two or more but-for causes. Sometimes there's two or more actual causes. Each could be said to have set in motion victim's death, and we've got to figure out who to blame. Let's use the following example as an illustration for this part of the discussion. Defendant shoots the victim. Then an ambulance arrives to take the victim to the hospital. But on the way to the hospital, ambulance crashes, and victim dies as a result of that ambulance crash. What do we have here? We seem to have two causes that have contributed to victim's death. Which one of those two causes should be responsible? So let's bring up our but-for test to determine actual causes. First, we would say that but for defendant shooting victim wouldn't have ended up in the ambulance on the way to the hospital for it to crash. That makes sense. So far, so good. Defendant set that part in motion. But we have a second but for we could use, a second actual cause. We can say also that but for the ambulance crashing, the victim wouldn't have died. So using the but-for test has provided us with important information. It has identified two factual causes or two actual causes of victim's death. But we can't rest there. We've got to pick between the two. And here's where it gets a little tricky. We need to make a decision between those two causes who should be responsible. We need to ask whether D remains responsible or whether it's unfair to say that in this case, the social harm wasn't really caused by defendant's conduct. It was really caused by the ambulance. That's why we have to determine the legal or proximate cause. Thorny issues of proximate causation generally arise when a force comes into play after defendant's act. I want you to imagine this as a timeline. We call this an intervening act. It means when a causal agent comes into play after defendant's action or omission and before victim dies. Generally, intervening acts fall into three categories. There's the act of God, lightning, earthquake, mudslide. It's not traced back to any human action. Or it's an act of a third party intervening, like we have here, the ambulance crashing. Or it might be an act of a victim that ends up contributing to his own death. In our hypothetical, the ambulance crashing is this intervening act. It comes into being after defendant's act of shooting, but before the victim dies. So which of these two factual causes, defendant shooting the victim or the ambulance crashing, should be the legal or proximate cause of the death? In our example, should it be defendant who set it all in motion by shooting victim? Or should it be the ambulance that had the crash that directly caused victim's death? There's one big difference between civil liability and criminal liability. Generally speaking, in tort law, potentially two different actors could be jointly liable for injuries suffered by a plaintiff, with one more financially responsible than the other. Not in criminal law. In criminal law, we need to select one party, or group joined by a conspiracy, and only one to be criminally responsible. That's the one party that will suffer the condemnation, go to prison for the criminal homicide. With our example of defendant shooting the victim and the ambulance crashing, here's the legal terminology we would use. We would say that defendant is the indirect cause of victim's death. Why indirect? That's because defendant is further back in the movie. Between defendant's act of shooting and victim's death, another activity happened. The ambulance crashing is an intervening act. So defendant's the indirect cause, and the ambulance, which is closest to victim's death, is called the direct cause. We're going to start with a general rule here that defendant is going to continue to bear responsibility for future intervening acts, providing that future intervening act is reasonably foreseeable. If we are at the start of the movie and see defendant shooting victim, could we imagine that this intervening act is foreseeable? If it is foreseeable, defendant remains liable. He bears the responsibility of having set everything in motion. He's going to be the legal or proximate cause. So in analyzing our shooting ambulance example, we might say that this intervening act of the ambulance crashing is actually reasonably foreseeable. Why? Well, the ambulance might crash. It generally speeds, it goes through red lights, it doesn't observe all the traffic laws, and we could imagine that the ambulance could crash. Since it's foreseeable that an ambulance might crash, defendant bears the responsibility of having set that in motion. He bears the responsibility of this chain of events. Therefore, we would say defendant's the legal or proximate cause of victim's death. The words legal and proximate cause mean the same thing. So that's what it looks like when defendant's still responsible. What kind of intervening acts would relieve defendant of responsibility? The law has a great phrase to describe this. We call it an intervening act that would cut the chain of causation from defendant and instead make the intervening act responsible. Let's take a wild example. Defendant still shoots victim, an ambulance still shows up, but now let's suppose a devastating earthquake happens while ambulance is on the road. The road develops this enormous crack, the ambulance plummets through, and everybody dies. Should defendant really be responsible for the deaths inside that ambulance? Intuitively, you already know that defendant shouldn't be responsible for this unforeseeable event that took place after his shooting. That wouldn't really be fair to him, even though he shot the victim. Legally, what would we say? Legally, we would say that this intervening act of this earthquake that caused the ambulance to crash cut the chain of defendant's responsibility. We even have a name for this kind of intervening act. We call it a supervening intervening act. It cuts the chain of defendant's liability. It's prominent. Now, this doesn't mean that defendant bears no culpability. Don't worry about that. He's still going to bear responsibility. He shot the victim after all. So depending on the circumstances, he could be convicted of attempted murder or convicted of assault. He's just not convicted of the criminal homicide because he didn't commit the homicide. He didn't cause victim's death.